Hey guys, welcome to today's video. This is going to be the fifth video for Unit 9 on civil rights and civil liberties. So today our focus is going to be on the first part of due process. I'm going to break this up into two videos just for time purposes. So today with due process, we're going to take a look at the Fourth Amendment in particular, and then also the right to privacy that we have as an implied right based on the Due Process Clause of the 14th Amendment. So our learning targets for this lesson are to summarize the protections of the Fourth Amendment, as well as a citizen's right to privacy, explain how the Supreme Court has attempted to balance these claims of individual freedom with laws and enforcement procedures that promote public order and safety, and explain the extent to which states are limited by this due process clause from infringing rights that we have as individuals, especially when we are accused of a crime or we are declaring our right to privacy. And remember that this different interpretation, this balancing act between individual freedom and public order and safety is going to be the framework that we are looking at through this unit. So I want to spend this first slide here reminding us about what due process is, and specifically due process in terms of the criminal justice system, which is where we're going to find a lot of our due process amendments and clauses come into play. So the criminal justice system is limited by the Bill of Rights. Ultimately, when we're looking at that Fifth and the 14th Amendment, we're looking at how the federal and the state governments are prevented from unfairly depriving citizens of their freedoms or possessions without being heard or receiving fair treatment under the authority of law. So I want to break this down here, right? This Fifth Amendment as a part of the Bill of Rights applies at the federal level. The 14th Amendment applies it to the state level of government. And ultimately, this is to protect vulnerable populations. And that could be accused persons of a crime, the poor and the indigent, ultimately the unborn, as we will see when we get into the right to privacy. And these due process clauses and these amendments have really expanded this incorporation doctrine. Exactly what liberties of the Bill of Rights have been expanded to fit state governments. Okay. Now, talking about due process, federal and state governments are prevented from unfairly depriving citizens of their freedoms or possessions without being heard or receiving fair treatment under the authority of law. These are those procedures of law, those actual actions that take place in our criminal justice system. So these would be questions like, did the local court give the defendant a fair trial? Did the zoning board accurately appraise the value of the citizen's house before seizing it under its legal powers? Were suspended students given the chance to explain their side of the story? Now, this is a requirement. That does not mean people are perfect, right? Sometimes due process does not happen. And when that does not happen, a failure to follow these limits set forward usually invalidates a conviction. That person is usually set free when we're talking about that criminal justice system. Now, that doesn't mean that your right to life, liberty, and property, or pursuit of happiness, whatever, can never be taken away, right? We know that's not the case. These are not absolute things. Your freedoms of possessions can be deprived, but it must be done in a specific prescribed manner. And that is what is outlined via due process. Right? And as I said, remember, because these are not absolute, we have to balance freedom with laws, order, and safety. And safety even includes national security, which we'll talk about later in this video. Right? Remember, the court has on occasion ruled in favor of states' power to restrict individual liberty. For example, Schenck v. US, when there is clear and present danger, your liberties can be restricted. And of course, what is necessarily balancing law and order is interpreted differently over time. What exactly is an unreasonable search? What exactly is cruel and unusual punishment? right? These are things that have changed tremendously since the founding fathers, beyond what they could have anticipated, especially as we will see with the Fourth Amendment when we talk about technology in our digital age. Now, when we talk about the Fourth Amendment, this provides or is a procedure of due process in that the Fourth Amendment prevents law enforcement from conducting unreasonable searches and seizures of your property and person. Now, this was very important for our founders to include because under British rule, before independence, Britain was really cracking down on smugglers who were trying to avoid those taxes, which, remember, we didn't want to pay because we were not represented fairly. And these British soldiers would ultimately blanket search or have blanket search warrants that allowed them to search any home, any warehouse, etc. at any time. It did not have to be specific. And this violated our sense as a new country or as a rebelling country of privacy and ultimately respect for our personal property. And as a result, the Fourth Amendment also not only protects your unreasonable searches and seizures, but also has an implied zone of privacy in it as well. Right? The first part of this amendment says the right of the people to be secure in their persons, houses, papers, and effects, right? To be secure in your person, right? That is establishing what we have considered to be an implied zone of privacy. It exists kind of in between the lines of the wording of the Fourth Amendment. So the Fourth Amendment, as a result, limits the federal government and the states really from emerging as an overpowering police state that abuses its power. When following the Fourth Amendment, law officials must gain a search or an arrest warrant, and they must have what is called probable cause. This is when the police have reason to believe that a person should be searched or arrested for an illegal act. This is much more than just a suspicion or a hunch. This is basically like pretty darn close to actual evidence that they will submit in order to be granted one of these warrants by a court. Now, in response to the conditions we were facing under Britain or British rule, these warrants must be specific in terms of the person who is being searched, where is being searched, and what is being seized, if anything. So, for example, the warrant will actually say the name of the person, and they can only search that person if it's granted. Let's say that they believe a crime was taken place or has taken place on someone's property. They have to list where on that property they can search. So maybe they only get permission to look in the house. They cannot look on the grounds, the land surrounding a house, for instance. The warrant has to list where specifically and then what is to be seized. And a search becomes, quote, unreasonable if the search is conducted haphazardly or randomly. So if it is ultimately done without probable cause, for instance, if there is not a justifiable warrant, that is considered unreasonable. And in those instances, the courts have called or declared an exclusionary rule. And this states that evidence, no matter how incriminating, even if it says without a doubt, beyond reasonable doubt that this person committed a crime, that evidence cannot be introduced into trial if it was not constitutionally obtained, right? So that is protecting people and individuals from a state or local government when they are not following this due process procedure, right, of you're protected by your Fourth Amendment. And ultimately, the case that incorporated this exclusionary rule and the Fourth Amendment to the states is one from Ohio, Mapp v. Ohio in 1961. Just a little background, 7 officers, broke into Mapp's home in search of a fugitive suspect. And basically, they were also looking for gambling paraphernalia. They found no person or evidence related to either of those, I should say. But what they did find was some obscene books and pictures, i.e. some pornographic materials. Mapp was then arrested and then sent to prison. But ultimately, because of this exclusionary rule, they did not have a warrant specific enough to find those things, to seize those things. The Supreme Court ruled that her Fourth Amendment rights had been violated, and they should have never discovered that illegal contraband. So as a result, she was actually, or her conviction, I should say, was overturned. Now, of course, there are exceptions and loopholes to the First Amendment. Searches can be warrantless, but you would still need to establish probable cause. So, for example, something like this would be if the cops are called to your house for like a disturbance call, but they see blood or maybe even something crazier like a dead body on the ground, right? They would have probable cause for them to enter your home. They can also ask for consent of the person being searched, and that is also an exception to like that warrant kind of clause of that Fourth Amendment. Now, there are exceptions to the exclusionary rule, right? We just said that if evidence is obtained haphazardly in an unreasonable manner, it can be excluded from testimony in a court. There are two exceptions to that. The first is inevitable discovery. And this happens when police find evidence in an unlawful search that would have eventually made the same discovery later in a lawful search, right? Basically, the court is saying, look, it doesn't matter at this point if it was lawful or not. It would have eventually come to light if it had been conducted properly. So therefore, it is an exception. Now, the more popular one, or the most common one, is going to be the good faith exception. And this is the case where maybe the officers believe they have a valid warrant that is later deemed invalid, erroneous, or unconstitutional at a later date. Due to this good faith exception, evidence could still be used in trial because the police conducted the search under the good faith, thinking that they were following the law. So that is a good faith, or the good faith exception. Exceptions to the Fourth Amendment protections are also under the category of searches in schools, right? We looked at with Tinker versus Des Moines, students' constitutional rights don't stop at the schoolhouse gate. You do retain some rights, but they are a little restricted as set forth by New Jersey versus TLO. Ultimately, this set the standard that school officials are not required to have the same level of probable cause as police are, right? I said before, probable cause is pretty dang close to evidence. At a school, you just have to have reasonable cause or suspicion. So this is why with Jules, right, if we have a suspicion, we do have permission to search your effects, your belongings. Now, the court also said that students have the legitimate expectation of privacy, but that must also be weighed against the interests of other teachers, of the administration, of other students. And ultimately, they have to think about the school's responsibility and mission. And also, exception-wise to the Fourth Amendment would be protection against warrantless searches of cell phone data and GPS locators. This is another way that the states are limited by due process, right? The states cannot just take your phone if you're accused of a crime and look through it. Ultimately, it prevents your rights as an individual from being eclipsed by the need for order and security. So they cannot just get your cell phone data without a warrant, or your GPS location in your car without a warrant. Okay, so the Fourth Amendment has come under some pretty big questions in our digital age, and there have really been two changes in our lifetimes that have challenged the balance between American freedoms and our national security when it comes to searches and seizures and the implied right to privacy. So the first is that there really has been a shift from traditional types of communication like print to electronic and cellular communication, right? We've seen a huge technological revolution that has happened, and also concern over terrorism post 9/11. These two changes in our world have led to kind of a new balance between what is freedom, especially when it comes to the Fourth Amendment, and the prevention of terrorism. So ultimately, to find terrorists and prevent future attacks, the US government has tried to capitalize on modern forms of investigation to use those new electronic and cellular technologies to investigate and even survey people who are suspected terrorists. Now, this has come under a lot of controversy because after 9/11, we see a few things happen. The very first thing is the USA Patriot Act, which stands for Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism. That's what it stands for. This act is passed in 2001. And what this did was allowed the executive branch to connect with third parties, and those third parties being businesses like Verizon, AT&T, telecommunications companies, right, that you get your cell phone and all of your minutes and things through. That allowed the executive branch to connect with them and acquire and examine cell phone data, no warrant needed, right? This third party relationship, right, if you're thinking like, wait, why don't they need a warrant here? When they're getting this information from a third party, this excuses the government from warrants as long as the third party is willing to give up the information. So it's really at this point kind of like asking a suspect's friend what the suspect, told them. And this has even been compounded by some actions by the NSA and other privacy concerns as well. It came out in 2013 that the NSA was collecting metadata. Metadata or metadata is data about data. Specifically cell phone data. They were collecting cell phone communication of citizens, and it was really communication minus actual conversation. So what it included was who was calling whom, when are they calling, for how long, okay? Ultimately, when this came out, it was actually a pretty big deal. If you've ever heard of Snowden, he's the one that blew the whistle on this program. And really, we had a huge blow up in terms of is this a Fourth Amendment violation or not? Right? The government contended that since these activities don't actually spy on the actual conversation, their actions are non-intrusive and in compliance with the Fourth Amendment, right? The government is saying our compelling interest, our goal is to determine who might be connected to terror suspects in the United States and to what degree, right? They're going to claim that delays would be associated with getting a court-ordered warrant each time the government wanted to monitor some metadata, and that would impede the government's ability to prevent future terrorist attacks. On the flip side of things, right, if the government is taking a look at this metadata and looking at who we are calling, when, and for how long, right, this data can then reveal very personal information, right, whether a person called something maybe like a rape crisis center, a suicide prevention hotline, a bookie, right, something illegal. So the question becomes, should the government be privy to such sensitive information? And this has been adjusted a little bit. In 2015, they passed the USA Freedom Act that alters the Patriot Act a bit. It doesn't completely eliminate the collection of and storage of metadata by cell phone operators, but it does prevent the government easy access to it, now requiring a warrant from the executive branch to examine this metadata. Now, this picture is kind of really showing you the controversy here, right? Does this metadata collection interfere with our individual right to privacy and our protection of unreasonable searches and seizures, or does it promote public safety in our age of terrorism? And these are really those ongoing debates about the extent to which government can monitor our private data and communications while still preserving the liberties of citizens against warrantless search and seizure. And this is a question that you guys will be tackling in our summary question at the very end of this video. Now, due process, as I've mentioned, also relates to this right to privacy. So due process, as we've talked about it so far, is procedural. The way the law is carried out, is it carried out in a fair, systematic manner, like those Fourth Amendment requirements, right? Probable cause, if it's not obtained in a probable manner or with probable cause or a warrant, it can be excluded. But due process can also be substantive. And this says that if the substance or point of the law, the very point of what the law is supposed to do, if that violates a basic right, even one not listed in the Constitution, a court can declare it unconstitutional. And that's where we ultimately get this right to privacy, the right of a private personal life free from intrusion by the government. And this was first brought to light in a case, Griswold v. Connecticut, which I actually had you guys take a look at when we were talking about selective incorporation. But really, this case is ultimately an issue of privacy as well. The court rules that an old anti-birth control state statute was in violation of the Constitution because of this right to privacy. This was the first time that it was emphasized that there was an inherent, an in between the lines, right to privacy, not listed in the Constitution, found really in the shadows, the penumbras, the shadows of the First Amendment, the Third Amendment, Fourth, and Ninth. So nowhere in the Constitution will you ever see the word privacy, but it has been inferred or implied to exist because of these amendments, and they have then been incorporated to the states. So there ultimately has been a controversy over this right to privacy, and that stems from Roe versus Wade. Roe versus Wade bolstered the right to privacy with its ruling, right? The question was, can states prevent a woman from an abortion? That was the question at hand. The decision of the court said that whether a pregnant woman was to have or abort her baby was a private decision between her and her doctor and outside the reach of government. So upholding that right to privacy. And it made it unconstitutional for a state to ban abortion for a woman during her first trimester, which is the first 3 months of pregnancy. And ultimately, we have to think about this, right? We know the court is always trying to balance liberty and order, right? This court case did uphold that right to privacy in the case of abortion, but we do have to also consider that privacy is not unlimited. The decision in Roe recognized that the government may regulate abortion in the second and third trimesters due to compelling state interests in maternal health, for example, and potential life. So while it was a case that bolstered privacy maybe in that first trimester, it's not unlimited. Okay. Now, the controversy today really is the pro-life versus pro-choice debate. Specifically, when does life begin? Is it upon conception? Is it when the fetus is viable or able to survive outside of the womb without the mother's support? And that's typically around 22 weeks. So you will see both the pro-life and pro-choice targeting Roe v. Wade for their own purposes, whether it's to continue abortion for the safety of a mother, for example, if you're pro-choice, or for the life of a baby, or pro-life, trying to strike down Roe v. Wade and what it stands for. Okay, so that is the controversy surrounding it. Now, I want you guys to head to Google Classroom, and I'm going to have us thinking about this summary question. This is just a short answer to a pretty hefty question that I want you guys to answer. So today we talked about the Fourth Amendment and the rights of privacy. Right. And this Fourth Amendment protects you from unreasonable searches and seizures and implies that you have the right to privacy in your person, your house, your effects. So I want you guys to type a response. In your opinion, is the government's collection of digital metadata something that promotes public safety, or is it something that interferes with individual liberties? Does national security outweigh the right to privacy? And I want you guys to explain your reasoning. So that prompt you will find underneath your notes for this section. Make sure to write down any questions you have and log on during office hours if you would like to talk about them. And I will talk to you guys soon. Bye.